Every year in England and Wales, 2 women a week are killed by a current or former partner. Not by strangers, not in random attacks, by someone they knew, someone they had history with, someone they had often already reported to the police. Most of those women did not die without warning. Most of them had reached out, made calls, filed reports, let officers into their homes, trusted a system that exists specifically for moments when a person's life is in danger. Joanna Michael did all of that. She was 25 years old, she had 2 children, and she called 999 and told the operator her ex-partner had just threatened to kill her. The nearest police station was 5 minutes from her front door. She was dead within 16 minutes of making that call. Today we are covering what happened inside those 16 minutes, why it happened, and what the highest court in the United Kingdom said about it when her family tried to get answers. Section 1. Who Joanna Michael was. Joanna Michael was 25 years old. She lived at a house in St Mellons, a residential area on the eastern edge of Cardiff in South Wales. She had 2 children, a 7-year-old and a baby who was just 10 months old. Both children were in the house with her on the night she died. She was not in a relationship with Siren Williams anymore. That was over. She had moved on, she had a new partner, and she was living her life. Whatever had happened between her and Williams before, that chapter had closed. She was a young mother with a baby under a year old and a primary school-aged child, doing what young mothers do. Getting up in the mornings, getting through the days, building something going forward. Her home in St Mellons was where she felt safe. It was where her children slept. It was the place she had chosen to make her life after the relationship with Williams ended. What most people reading about this case do not immediately register is that Joanna had already tried to get help. This was not a situation where she had stayed silent, never reported anything, and then one night something terrible happened out of nowhere. She had reported the abuse. She had called the police before. Between September 2007 and April 2009, nearly 2 years of documented incidents, South Wales Police had attended her home at least 4 times because of domestic incidents involving Siren Williams. Her name was on their system. Her address was on their system. Her history with this man was on their system. Each time officers attended, they were supposed to fill out what is called a Public Protection Referral Form for domestic abuse. This is a standard document. It exists specifically to help police understand the level of danger a person is facing, so that if something happens again, the officers responding already know the background. One of the most important parts of that form is the risk assessment section, the part where officers record whether the person is at low risk, medium risk, or high risk of further harm. On 2 of the 4 occasions police attended Joanna's home, that section was left blank. Not filled in as low risk, not filled in at all, just blank. That matters more than it might seem at first glance. Those forms are not admin for the sake of admin. They feed directly into how seriously a future call gets treated. If a woman's risk level has been properly recorded, a call handler receiving a 999 call from her address at 2 in the morning has context. They know this is not a first incident. They know there is a pattern. They know the level of danger that has already been assessed. When those forms are incomplete, that context disappears. The next person handling the call is working in the dark. So when Joanna picked up her phone at 2:29 in the morning on August 5th, 2009, she was calling into a system that had her name on file, but not her full story. A system that had been to her house 4 times, but had not completed its own paperwork on 2 of those visits. A system that knew Siren Williams existed in her life, but had not formally recorded how dangerous he was. She had done everything asked of her. She had let police into her home. She had reported what was happening. She had cooperated with a process that is supposed to protect people in exactly her situation. And in return, the process had left 2 risk assessment boxes empty. On the night she died, Williams had turned up at her home without warning, in the middle of the night, and found her with her new partner. He physically assaulted her. He bit her ear hard enough that it was noted in the subsequent investigation. He took her new partner away in his car, and before he left, he told Joanna he was coming back. He told her he was going to kill her. She believed him. She had been in a relationship with this man. She knew what he was capable of. She knew the difference between an empty threat shouted in anger and a statement of intent from someone who meant it. Whatever fear she felt in that moment was not paranoia or overreaction. It was the informed judgment of a woman who had spent years dealing with a violent ex-partner and who understood, in a way that no call handler or patrol officer could from a 2-paragraph summary, exactly what Siren Williams was telling her when he said those words. So she did what you are supposed to do. She called 999. She was inside her own home. Her 10-month-old baby was upstairs. The nearest South Wales police station was 5 minutes away from her front door. 5 minutes. In the time it takes to make a cup of tea, an officer could have been standing at her door. What happened to that call? Who answered it? What was heard? What was passed on? And what was left out? Became the subject of a full investigation by the Independent Police Complaints Commission. Multiple court cases, including a hearing at the UK Supreme Court and a debate in the House of Commons. It changed the way legal experts, domestic violence charities, and lawmakers in Britain talk about what the state owes the people who ask it for help. But in the moment, it was just a young woman in a house in Cardiff with a baby upstairs and a man coming back down the road. She had about 16 minutes left to live. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. The call she made at 2:29 a.m. lasted just over 3 minutes. What happened inside those 3 minutes, and what one distracted call handler failed to pass on, is where everything that followed began. Section 2. The relationship with Siren Williams and the documented history of abuse. Joanna and Siren Williams had history. Not the kind that fades quietly into the background when two people split up. The kind that follows someone home, shows up uninvited, and refuses to accept that it is over. The relationship had been volatile. That word gets used a lot in domestic abuse cases, and it can start to lose its meaning, so it is worth being specific about what volatile meant here. It meant police had been called to Joanna's address because of incidents involving Williams on at least 4 separate occasions. The first recorded incident was in September 2007. The last one before her death was in April 2009. That is a span of nearly 2 years. 4 call-outs across nearly 2 years is not a rough patch. It is a pattern. South Wales Police had a file on this. They had attended her home. They had spoken to her. They had filled out domestic abuse referral forms, the documents designed to track risk and ensure that if something happened again, the people handling the next call would know what they were dealing with. Except, as already covered, 2 of those 4 forms had the risk assessment section left blank. The paperwork existed. The warnings were not fully written into it. What the forms did record was enough to establish that Joanna Michael was a known victim of domestic abuse at the hands of Siren Williams, and that this had been an ongoing issue going back at least to late 2007. That information was sitting in the South Wales police system on the night she died. Now, by August 2009, the relationship was over. Joanna had moved forward. She had a new partner. She was getting on with her life in the way that people are supposed to be able to do after leaving a difficult relationship. The fact that she had managed to separate from Williams and was building something new for herself and her 2 children is worth stating plainly, because it matters for understanding what Williams did next. He did not handle the separation well. On the night of 4th August 2009, going into the early hours of 5th August, Joanna's new partner was at her home in St Mellons. Williams turned up without warning in the middle of the night. He had not been invited. There was no reason for him to be there. He arrived and he found Joanna with another man, and whatever was already unstable inside him at that point broke open completely. What followed happened in Joanna's home in the middle of the night while her children were there. Williams physically assaulted Joanna. He bit her ear, not a push or a shove, but a bite hard enough that it was documented in the investigation that came afterward. He then took Joanna's new partner and forced him out of the house, putting him in his car. The accounts describe him bundling the other man out, removing him from the scene. Some have described this as Williams acting in what a judge later called a mad fit of jealous rage. Before Williams left with Joanna's partner in the car, he turned to Joanna and told her what was going to happen next. He said he was coming back, and he said when he came back, he was going to kill her. Those were not words spoken in passing. He left. He drove away. And Joanna was standing in her house, knowing he was going to return, knowing what he had just said, and knowing from nearly 2 years of experience with this man whether or not she should take him seriously. She took him seriously. That is when she called 999. Not after he came back. Not when she heard his car outside. She called immediately, while he was still gone, because she understood that the window between him leaving and him returning was the only window she had. She was trying to get help in the gap. She was trying to get someone there before he came back. It is also worth being clear about what she was not doing in that call. She was not vague. She was not unsure whether to involve the police. She did not minimize what had just happened or hedge around the threat he had made. She told the operator directly that her ex had just assaulted her, that he had taken her new partner away, and that he had said he was coming back to kill her. She said he was going to be back any minute. She was specific. She was clear. She was asking for immediate help. The broader context of Williams as a person in Joanna's life is important here, because it shapes what her call actually represented. This was not a first incident being reported by someone who had never dealt with this man before. This was the latest moment in a 2-year documented history of abuse, reported by a woman who had already worked within the system, already had police to her door multiple times, and who was now telling that same system that the threat had escalated to the point where he had said the words out loud. He said he was going to kill her. She reported it immediately. She gave the operator everything they needed. What happened to that information once it entered the 999 system, how it was received, what was heard, what was missed, and what was never passed on, is the part of this case that the IPCC investigation, the court proceedings, and the parliamentary debate all circled back to again and again. Because the failure did not happen in Joanna's home before she called. It happened on the other end of the line, in a control room, while she was waiting for help that was already 5 minutes away. That call, and everything that went wrong inside it, is what Section 3 covers. Section 3. The first 999 call, 2:29 a.m. Joanna called 999 at 2:29 in the morning on August 5th, 2009. She made the call from her mobile phone. She was inside her home in St Mellons. The nearest South Wales police station was 5 minutes away from her front door. Under normal circumstances, with a correctly routed call and an immediate response grade, officers could have been standing at her door by around 2:35 a.m. 6 minutes. That is the timeline that should have existed from the moment she dialed. It did not exist, because the call never reached South Wales Police directly. Mobile phones in 2009 did not automatically connect to the local police force the way a landline would. They connected through whichever telephone mast picked up the signal. Joanna was standing in St Mellons, which sits right on the border between the South Wales Police area and the Gwent Police area. The mast that picked up her signal that night was across the county border in Gwent, so her call was automatically routed to the Gwent Police Control Room, not the South Wales Police Control Room that covered her address. This was not a mistake she made. She dialed 999 correctly. The number went through. The system simply sent it to the wrong place. A known technical flaw in how mobile 999 calls were handled at the time, which the Independent Police Complaints Commission later identified as a systemic problem built into the infrastructure itself. The Gwent police call handler who received the call was a civilian operator. Her name was Ms. Mason. She answered, and Joanna told her what had just happened. Joanna said her ex-boyfriend had turned up at her house in the middle of the night. She said he had found her with another man. She said he had bitten her ear and assaulted her. She said he had taken the other man away in his car. She said he was aggressive. She told Ms. Mason that Williams had said he was coming back, and that he was going to be back any minute, literally. Those were her words. Any minute, literally. She was not speaking calmly about something that might happen. She was telling the operator that the threat was immediate, that she was alone, and that she needed help right now. The call lasted just over 3 minutes. At some point during those 3 minutes, Joanna said something beyond just, "He is going to come back and hit me." The recording of the call captured the words, "fucking kill you," being spoken. The IPCC investigation and the subsequent court proceedings confirmed that those words were on the tape. A transcript was produced. The words were there in black and white. Ms. Mason later gave an account of what she heard and did not hear during the call. She said she had heard and understood Joanna when she said Williams was going to come back and hit her, but she said she did not hear the words "kill you" during the call itself. She acknowledged in her statement that on listening back to the recording afterward, she could hear those words. She acknowledged that the transcript confirmed they were said, but in the moment, she said, she had missed them. Her explanation for why she missed them is one of the most important details in the entire case. Ms. Mason said that for periods of time during the call, she was very distracted. She explained that at the same time she was listening to Joanna, a radio request from a police dog handler was coming in on a separate channel. She was handling two things simultaneously. She also said that she was aware, from early in the call, that the incident was in the South Wales police area and not Gwent, which meant all the details were going to have to be taken again by South Wales police anyway. She knew she was going to be handing the call off. In her own words, she was more concerned at the time with the safety of the other man who had been taken away by Williams in the car than with anything else Joanna was saying. So while Joanna was on the phone telling her that her ex was coming back to kill her, the person on the other end was mentally already halfway through the handover to a different control room. The call ended with Ms. Mason telling Joanna that the call had come through to Gwent Police by mistake and that she would pass it on to the police in Cardiff. She told Joanna to keep her phone free because South Wales Police would want to call her back. Joanna said all right, and the call ended. Miss Mason then did what she said she would do. She contacted the South Wales Police control room to pass on the information. But what she passed on was a trimmed-down version of what Joanna had told her. She told her South Wales counterpart that a woman's ex-boyfriend had turned up at her house, that there had been an incident, that he had taken another man away, and that he had threatened to come back and assault her. She did not mention that Joanna had said he was going to kill her. That one missing detail, 3 words that were on the tape, confirmed in writing, audible to anyone who listened back to the recording, is what caused the response to be graded the way it was. Because the South Wales operator receiving that handover heard a domestic incident involving a threat to assault, not a direct threat to kill. And that distinction, in a grading system built on the information provided, meant everything. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. The call that had been correctly logged as Grade 1, immediate response, 5 minutes, was about to become something far less urgent. What happened in the South Wales control room in the minutes after that handover, and the decision that was made there, is what Section 4 covers. Section 4. The handover failure. What was and wasn't passed on. When Ms. Mason ended the call with Joanna, she had one job left to do: pass the information to South Wales Police so they could send someone to the house. That handover, a routine part of how misdirected 999 calls were supposed to be handled, was the last real opportunity to get officers moving towards St Mellons in time. The South Wales Police civilian call handler who received that handover was a man named Mr. Gould. He was working in the South Wales Emergency Control Room. He did not speak to Joanna directly. He did not hear her voice. He did not hear the recording. Everything he knew about the situation came from what Ms. Mason told him in that brief transfer of information. What Ms. Mason told him was this: a woman's ex-boyfriend had turned up at her address in the middle of the night. There had been an altercation. The ex had taken another man away in his car, and he had threatened to come back and hit her. That was it. No mention that the words "kill you" had been spoken. No mention that Joanna had said he was going to be back any minute, literally. No mention of the bite to her ear. No mention that there were children in the house. The summary Mr. Gould received was accurate as far as it went. There was a domestic incident, a threat to return and assault, and a woman waiting at home. But it was stripped of the details that would have told him this was a situation requiring immediate deployment rather than a measured response. Mr. Gould took what he had been given and made a grading decision. He downgraded the call from Grade 1 to Grade 2. Grade 1 meant an immediate response. Under that grade, officers were expected to reach the address in around 5 minutes. Given that the nearest South Wales police station was 5 minutes from Joanna's front door, a Grade 1 response meant someone could realistically have been at her house by approximately 2:35 a.m, 6 minutes after she first called. Grade 2 meant a priority response. Under that grade, officers had up to 60 minutes to attend. A 6-minute response became a 60-minute window with a single grading decision made by a man working from an incomplete summary of a 3-minute phone call he never heard. The officers on mobile patrol were then informed of the incident. What they were told reflected the downgraded assessment, a domestic situation requiring a priority response. They were not told a woman had explicitly stated her ex was coming back to kill her. They were not told the call had originally been logged as immediate. They were not told about the history of domestic abuse attendances at that address going back to 2007. They received a priority-graded domestic call, and they responded to it as exactly that. This is where the layering of failures becomes visible. It was not one person making one mistake. It was a sequence. The mobile phone infrastructure sent the call to the wrong force. Ms. Mason missed the threat to kill because she was distracted. The handover she gave Mr. Gould omitted the most critical detail. Mr. Gould downgraded the response based on the incomplete picture he had been given. The patrol officers acted on the information they received. At every single stage, the outcome of the previous stage shaped what happened next, and at every single stage, something had already gone wrong. The IPCC investigation later confirmed that the original Grade 1 classification should have been maintained throughout. The decision to downgrade was identified as a failure. The IPCC named both individual failings: the distracted call handler, the incomplete handover, the downgrade decision, and systemic failings, including the mobile phone misdirection problem, and what they described as a lack of proactive intervention, given Joanna's documented history with South Wales Police. Both forces accepted the IPCC findings in full. Mr. Gould was subject to disciplinary proceedings. Ms. Mason faced a gross misconduct panel. Those outcomes came later, after the investigation, after the reports were written, after the Supreme Court case ran its course. In the early hours of August 5, 2009, none of that had happened yet. The grading decision had been made, the patrol officers had been informed, and the clock was moving. There is a specific detail about the timing that the IPCC put on record in plain terms. At 2:29 a.m, when Joanna made her first call, an immediate police response could have reached her house in 5 minutes. That means officers could have been at her door by 2:35 a.m. at the latest. Because of the combined failures, the misdirection, the missed threat, the incomplete handover, the downgrade, the emergency response did not arrive until 2:51 a.m, 22 minutes after her first call. The IPCC's own report stated that Joanna had been stabbed at approximately 2:45 a.m., 16 minutes after she first called for help, 6 minutes before anyone arrived. The IPCC was careful in how it framed the counterfactual. It did not say that a faster response would definitely have saved her life. It acknowledged that Williams might have waited for officers to leave before returning. What it said, in clear language, was that more could and should have been done for Joanna, and that she was denied the opportunity for a prompt response which may have led to a different outcome. May have led to a different outcome. That phrase sits in the official record. It does not confirm she would have survived. It confirms she had a chance, and that the system took that chance away from her through a series of failures that started with a distracted call handler and ended with patrol officers heading to an address they had been told could wait an hour. Joanna was still at home while all of this was playing out in control rooms. She had been told to keep her phone free. She was waiting for a callback that records show never came. And Williams was on his way back. What happened when he arrived, and what the second 999 call captured, is what Section 5 covers. Section 5. The second 999 call and the arrival of police. 2:43 a.m. to 2:51 a.m. At 2:43 a.m., 14 minutes after her first call, Joanna called 999 again. The call was received by Gwent Police, not South Wales Police. Gwent again. The same misdirection, the same technical failure, the same wrong control room. For the second time that morning, Joanna's call for help landed with a force that had no jurisdiction over her address and no officers positioned to reach her. This call was different from the first one. There were no details given, no explanation of what had happened or what was happening, no address, no name, no description of the threat. What the Gwent operator heard when they answered was screaming. Joanna was screaming, and then the line went dead. That was the entire call. In the space of 14 minutes, the situation had gone from a woman alone in her house, waiting for a callback that never came, to a woman screaming into a phone before the call cut off. The shift between those two moments is not gradual. It is a cliff edge. At 2:29 a.m., she was frightened and asking for help in full sentences. At 2:43 a.m., she was screaming and then silent. When the Gwent operator heard the screaming and the line drop, they upgraded the incident to immediate. That upgrade, the response level that should have been applied from the very first call at 2:29 a.m., finally happened at 2:43 a.m., 14 minutes too late to make the difference it would have made at the start. South Wales Police were informed of the upgrade. Officers were now moving toward Joanna's address as an emergency. But the timeline of what else was happening around the same period fills in the picture of what those final minutes looked like from the outside. At 2:46 a.m., a member of the public called 999. Their call was also misdirected to Gwent Police. That caller told the operator there was a domestic dispute at Joanna's address. They said they could hear children screaming. The children, a 7-year-old and a 10-month-old baby, inside that house. 3 minutes later, at 2:49 a.m., another member of the public called. That call also went through to Gwent Police. That caller told the operator that somebody had been stabbed at Joanna's address. Gwent Police immediately called for an ambulance and passed the information to South Wales Police. At 2:51 a.m., South Wales police officers arrived at Joanna's home. They found her inside. She had been stabbed. She was dead. The IPCC report recorded that Joanna was stabbed at approximately 2:45 a.m. That is the timeline as the official investigation established it. She called at 2:29 a.m. She was stabbed at approximately 2:45 a.m. Police arrived at 2:51 a.m. 16 minutes passed between her first call and her murder. 6 minutes passed between her murder and officers walking through the door. The number that has been reported and confirmed across court documents, news coverage, and the IPCC findings is this. By the time police arrived, Joanna had been stabbed 72 times. 72 times. That number is not an estimate or a rough figure from an early report. It was confirmed through the investigation and referenced in parliamentary debate when Joanna's case was raised in the House of Commons. It is the number that tells you this was not a single act of violence that happened to be fatal. This was sustained, repeated, frenzied. The judge, who later presided over Williams's case, described it as the result of a mad fit of jealous rage. Cyron Williams was arrested shortly after officers arrived at the scene. He did not flee the area. He was found and taken into custody. Joanna's 2 children were in that house while this happened. The 7-year-old and the 10-month-old baby, whose mother had called the police 14 minutes earlier and been told to keep her phone free for a callback. A callback that the records show never came during those 14 minutes she was left waiting. The members of the public who called at 2:46 a.m. and 2:49 a.m. were not police officers, not trained responders, not people with access to patrol cars or radios. They were ordinary people who heard something wrong and picked up a phone. The first one heard children screaming. The second one knew someone had been stabbed. Between them, they provided more actionable information in those 3 minutes than the official handover between 2 police forces had provided in the 14 minutes before. That is not an editorial point. It is just what the timeline shows. South Wales police officers arrived 5 minutes after the call was upgraded to immediate following Joanna's second 999 call. 5 minutes is exactly what the IPCC had identified as the response time possible from the moment of her first call at 2:29 a.m, had the Grade 1 classification been maintained. The distance between Joanna's house and the nearest station had not changed. The geography was the same at 2:51 a.m. as it was at 2:29 a.m. What changed was that by 2:51 a.m, there was nothing left for that 5-minute response to do. Everything that happened in those 22 minutes, from the first call to the arrival of officers, was later examined in detail by the IPCC, argued through multiple levels of the court system, and raised on the floor of the House of Commons. The investigation that followed produced official findings, disciplinary proceedings, and a Supreme Court case that went all the way to 7 justices, ruling on what the state owes the people who call it for help. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. Williams pleaded guilty to murder. His conviction, his sentence, and the legal battle Joanna's family then had to fight just to get any form of accountability from the 2 police forces that failed her. That is what Section 6 covers. Section 6. Cyron Williams. Conviction and sentence. Cyron Williams did not go to trial. He pleaded guilty to the murder of Joanna Michael. There was no jury, no weeks of contested evidence, no defense lawyers arguing that something other than what everyone already knew had happened. He admitted it. He was convicted of murder and sentenced to life imprisonment with a minimum tariff of 20 years. A minimum tariff means exactly what it sounds like. It is the minimum amount of time a person must serve before they can be considered for parole. It is not a release date. It is not a guarantee. But it is a threshold. The point at which the parole board can begin to assess whether someone is safe to release back into the public. For Cyron Williams, that threshold was set at 20 years from the date of his conviction. He was a man who turned up at his ex-partner's home in the middle of the night, physically assaulted her, told her he was going to kill her, left, came back, and stabbed her 72 times while her 2 children were in the house. The minimum period the courts determined he needed to serve before anyone would even begin to consider his release was 2 decades. Joanna's children, the 7-year-old and the 10-month-old baby, would be adults before that threshold was even reached. The conviction itself was not complicated or disputed. Williams pleaded guilty. The facts were not in question. What followed his conviction, however, became one of the most significant and painful legal battles in recent Welsh legal history. Not because of anything Williams did in a courtroom, but because of what Joanna's family tried to do after he was sentenced. They tried to hold the police accountable. Joanna's parents and her 2 children brought a civil claim against the Chief Constable of South Wales Police and the Chief Constable of Gwent Police. The claim had 2 parts. The first part was a negligence claim, an argument that both police forces had been careless in how they handled Joanna's 999 calls, and that this carelessness had contributed to her death. The second part was a human rights claim, an argument that the police had failed to protect Joanna's right to life under Article 2 of the European Convention on Human Rights, which is given legal force in the UK through the Human Rights Act 1998. The negligence claim was the more straightforward of the 2 to understand. The argument was simple. Joanna called 999, told the operator her ex had threatened to kill her, the operator missed the threat, the information passed to South Wales Police was incomplete, the response was downgraded, and she was murdered in the window created by that downgrade. If the police had not been negligent, if the call had been handled correctly, the threat passed on, and the Grade 1 response maintained, officers would have been at her door in 5 minutes. The negligence claim said the police should be financially liable for the consequences of that failure. The police applied to have both claims struck out before they could go to a full trial. They argued that under English and Welsh law, they did not owe Joanna a duty of care that could give rise to a negligence claim. The first judge to hear the case, Judge Jarman QC, declined to strike the claims out. He said the family should be allowed to pursue both arguments. The police appealed. The Court of Appeal then ruled in favour of the police on the negligence claim, applying a legal principle that had been established in a 1989 case called Hill v Chief Constable of West Yorkshire, a case that arose from the Yorkshire Ripper investigation. That principle, sometimes called police immunity, holds that police forces do not owe a private law duty of care to individual members of the public when carrying out the investigation or prevention of crime. The Court of Appeal said this principle applied to Joanna's case, and that the negligence claim could not proceed. However, the Court of Appeal also ruled that the human rights claim, the Article 2 argument, should be allowed to continue to a full trial. That was a significant finding. It meant that even though the negligence route was closed off, there was enough evidence of a real and immediate risk to Joanna's life, and enough questions about how the police had responded to that risk to justify a full examination in court. Both sides then appealed to the UK Supreme Court. Joanna's family appealed against the dismissal of the negligence claim. The police appealed against the ruling that the human rights claim should go to trial. In January 2015, the Supreme Court handed down its judgment. 7 justices heard the case. On the negligence claim, they ruled against Joanna's family by a majority of 5-2. They upheld the police immunity principle. They confirmed that under current English and Welsh law, police forces cannot be sued for negligence arising from how they handle emergency calls or carry out crime prevention. The 2 dissenting justices, Lord Kerr and Lord Clark, argued that the case for imposing a duty of care was strong enough, particularly given the known domestic abuse history and the specific threat made during the 999 call, that the law should develop to reflect it. They were outvoted. On the human rights claim, all 7 justices unanimously dismissed the police's appeal. The Supreme Court confirmed that the Article 2 claim should proceed to trial. They found there was sufficient evidence of a real and immediate risk to Joanna's life that the police knew about or should have known about, and that the question of whether the state had done enough to protect her right to life was a matter that deserved full judicial examination. So the family left the Supreme Court in January 2015 with a split outcome. The negligence door was permanently closed. The human rights door remained open. What that split outcome meant in practical terms for Joanna's children, for the police forces involved, and for the wider question of whether any real accountability was ever delivered, that is what Section 7 covers. Section 7. The IPCC investigation. Official findings. Before Joanna's family ever reached the courts, there was an investigation. The Independent Police Complaints Commission, the IPCC, which has since been renamed the Independent Office for Police Conduct, launched a full independent investigation into how Joanna's two 999 calls had been handled on the night she died. This was not a review carried out by South Wales Police or Gwent Police looking at their own conduct. It was an external body with the specific function of independently examining serious complaints and incidents involving police forces in England and Wales. The investigation was independent in the formal, institutional sense of that word. The IPCC completed its investigation and published its findings in July 2010, approximately 11 months after Joanna's murder on August 5, 2009. The conclusion was unambiguous. Joanna Michael had been failed by Gwent Police, South Wales Police, and the 999 system itself. That is not a paraphrase or an interpretation of the findings. That is the language the IPCC used in its official report. 3 separate entities, 2 police forces, and the infrastructure of the emergency call system were identified as having contributed to the failure. The report did not apportion blame equally between all 3, or suggest that any single factor was solely responsible. It found that the failure was the product of both individual errors and systemic problems, and that those 2 categories had combined on the night of August 5, 2009 in ways that denied Joanna the response she needed. The individual failings were specific and named. Ms. Mason, the Gwent call handler, was found to have failed in the performance of her duties. She faced a disciplinary panel on a charge of gross misconduct, the most serious category of misconduct in the police disciplinary framework. The South Wales call handler, Mr. Gould, was also found to have failed in the performance of his duties and faced separate disciplinary action. The IPCC Commissioner for Wales at the time, Tom Davis, addressed the findings publicly. He described what had happened to Joanna as the result of a fatal combination of technological and human errors. He said Joanna had rung the police because she needed urgent assistance and had been denied timely help. Both of those statements are in the official record. The systemic failings the IPCC identified went beyond the 2 individuals involved on the night. The mobile phone misdirection problem, the fact that Joanna's calls were routed to the wrong force because of which telephone mast picked up her signal, was identified as a structural issue with the 999 system that existed independently of anything Ms. Mason or Mr. Gould did or did not do. The problem had been known about. It was not unique to Joanna's case. The IPCC noted it as a systemic failure, precisely because it was the kind of problem that required a structural fix, not just individual retraining. The incomplete domestic abuse referral forms from the previous 4 attendances at Joanna's address were also identified as part of the systemic picture. The IPCC report pointed to what it called a lack of proactive intervention in terms of how Joanna had been dealt with in the past by South Wales Police in relation to the domestic violence incidents. The 2 risk assessment sections left blank on those forms were not just administrative oversights, they were part of a pattern of incomplete record keeping that meant Joanna's full history with Williams was not properly captured in the system that was supposed to protect her. Both South Wales Police and Gwent Police accepted all of the IPCC's recommendations in full. That acceptance matters because it means neither force disputed the findings or argued that the investigation had reached the wrong conclusions. They accepted that Joanna had been failed. They accepted the recommendations for how to address the individual and systemic problems identified. Both forces also issued apologies for their mistakes and failures. The IPCC was careful about one specific question that the findings inevitably raised: whether a faster response would have saved Joanna's life. The report addressed this directly and honestly. It stated that the IPCC could not say that an earlier response would have saved her. It acknowledged the possibility that Williams might have waited for officers to leave before returning to resume his attack. It did not pretend to know what would have happened in a counterfactual where the response had been immediate and officers had arrived by 2:35 a.m. What it said instead was precise and deliberate. More could and should have been done for Joanna. She was denied the opportunity for a prompt response, which may have led to a different outcome. That is the official position of the independent body that investigated the case. Not a certainty that she would have lived, a confirmation that she deserved better than she got, and that what she got fell below the standard she was entitled to. Tom Davis added one further statement in the public release of the findings. He said that no amount of learning from this tragic case would assuage the grief that Joanna's family were enduring. Joanna, her children, and her whole family had all been let down by the service she received on August 5, 2009. The IPCC investigation gave the family something the courts initially could not: an official, public, documented acknowledgement from an authoritative body that the system had failed Joanna. It named the failures. It named the people responsible. It produced recommendations that both forces accepted. It put on record, in plain language, that what happened to Joanna was not simply the result of one man's violence. It was also the result of a system that did not do what it was supposed to do when she reached out to it. That official finding became the foundation of everything the family pursued through the courts afterward. But the IPCC findings, as significant as they were, carried no financial consequences for the police forces involved. The apologies were given. The recommendations were accepted. And Joanna's children, the 7-year-old and the baby, were left with neither their mother nor any financial accountability from the institutions that failed her. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. Whether that financial accountability was ever going to be possible, and what the answer to that question revealed about the law as it stood, is what Section 8 covers. Section 8. The Supreme Court Case. Michael versus Chief Constable of South Wales Police. The case that Joanna's family brought against the two police forces eventually became one of the most significant legal cases in modern British law, not because of what it resolved, but because of what it confirmed was still broken. The full legal title of the case is Michael versus Chief Constable of South Wales Police. It was heard at the UK Supreme Court in 2015, 6 years after Joanna's death. The claimants were Joanna's parents and her 2 children. The defendants were the Chief Constables of South Wales Police and Gwent Police. The family was represented by Nicholas Bowen QC, who told the Supreme Court that the case was desperately important, particularly in the context of domestic violence victims and what protection the law offered them when the police failed to act. To understand what the family was arguing and why it mattered, it helps to understand the 2 separate claims they brought. The first was a negligence claim under common law. The argument was that both police forces had been negligent in how they handled the 999 calls, and that as a direct result of that negligence, Joanna was murdered. In most areas of life, if a professional or an organisation fails to take reasonable care and someone is harmed as a result, that person or their family can sue for compensation. Doctors can be sued for negligence, teachers can be sued, construction companies can be sued. The negligence claim argued that the police should be held to the same standard. The second was a human rights claim under Article 2 of the European Convention on Human Rights, the right to life. The Human Rights Act 1998 makes it unlawful for public authorities, including police forces, to act in ways that are incompatible with the rights protected under the Convention. The Article 2 argument was that the police had known, or should have known, that there was a real and immediate risk to Joanna's life, and that they had failed to take reasonable steps to protect it. These 2 claims are legally distinct. The negligence claim sits within common law, the body of law built up through centuries of court decisions. The human rights claim sits within the framework of the Human Rights Act and the European Convention. They require different legal tests, and they produce different outcomes if successful. The family pursued both because, given the legal landscape in England and Wales, both routes were necessary. The obstacle the negligence claim ran into was a principle established in 1989 in a case called Hill versus Chief Constable of West Yorkshire. That case arose because the mother of Jacqueline Hill, the final victim of the Yorkshire Ripper, Peter Sutcliffe, attempted to sue West Yorkshire Police for the failures in their investigation that she argued had allowed Sutcliffe to kill again. The House of Lords ruled against her. They held that police forces do not owe a private law duty of care to individual members of the public when carrying out the investigation or prevention of crime. That principle, known informally as police immunity, had been the law in England and Wales ever since. When Joanna's family brought their negligence claim, the police relied directly on that 1989 precedent. They argued that the same immunity applied, that handling a 999 call fell within the investigation or prevention of crime, and that no duty of care was owed to Joanna as an individual. The Supreme Court agreed with the police on this point by a majority of 5 judges to 2. Lord Toulson delivered the leading judgment for the majority. He confirmed that English law does not generally impose liability on a defendant for injury caused by a third party's conduct. He held that the police's duty for the preservation of the peace is owed to the public at large, not to specific individuals, and that this public duty does not give rise to a private law duty of care that individual members of the public can enforce through negligence claims. He acknowledged the tragedy of Joanna's case, but held that it was the role of Parliament, not the courts, to decide whether a public compensation scheme for victims of police failures should exist. The 2 dissenting justices, Lord Kerr and Lord Clark, disagreed. Lord Kerr argued that on the facts of Joanna's case, there was clearly a relationship of proximity between the police and Joanna that should have given rise to a duty of care. He said the criteria he would apply provided a workable basis to attach liability for glaring omissions by police forces without imposing an impossible burden. He and Lord Clark were outvoted. The negligence claim was permanently closed. On the human rights claim, however, the outcome was different. All 7 justices unanimously dismissed the police's attempt to have the Article 2 claim struck out. They found that the circumstances of Joanna's case, the known domestic abuse history, the explicit threat made during the 999 call, the question of whether the police knew or should have known there was a real and immediate risk to her life, raised issues of fact that required a full trial to resolve. The human rights claim was allowed to proceed. What this meant in practical terms for the family was stark. They had won the right to continue fighting, but the avenue that could have produced financial compensation through negligence, the route that could have provided material support for Joanna's 2 children growing up without their mother, was gone. Permanently. The apologies from both forces were already on record. The IPCC findings were already published. The disciplinary proceedings for the 2 call handlers had already run their course. And now the Supreme Court had confirmed that no negligence damages would ever follow. Both police forces issued a joint statement after the judgment. They said the case resolved an important point of law with implications beyond the specific facts. They said their thoughts remained with Joanna's family. They confirmed that an element of the claim, the human rights element, still remained subject to legal proceedings. The law that shielded them from the negligence claim had been built on a case from 1989. It remained in place in 2015. And it remained in place because 5 of the 7 most senior judges in the United Kingdom decided that changing it was a job for Parliament, not for the courts. Whether Parliament ever took that job seriously, and what the wider response to Joanna's case looked like beyond the courtroom, is what Section 9 covers. Section 9. The political response and the wider implications. The Supreme Court judgment landed in January 2015, and it did not stay inside the legal world. Within weeks, Joanna's case was being raised on the floor of the House of Commons. Wayne David, the Labour MP for Caerphilly, brought the case directly to the attention of the Leader of the House, William Hague. He asked for a parliamentary debate with a view to changing the law so that police would be held to account in the same way as doctors, teachers, and the armed forces. His argument was straightforward. Every other profession that holds a duty of care toward the public can be sued for negligence when that duty is breached and someone is harmed. The police were the exception. He wanted to know why, and he wanted Parliament to address it. William Hague, as Leader of the House, confirmed that the case would be referred to the Ministry of Justice for consideration. That referral was significant in one sense. It meant the case had reached the level of government attention where a formal review was at least being promised. But a referral to the Ministry of Justice is not legislation. It is not a change in the law. It is an acknowledgement that the issue exists and that someone in government will look at it. Whether that looking ever produced anything concrete is a separate question, and the answer to it reflects a pattern that runs through the entire aftermath of Joanna's case. The acknowledgements came, the commitments to review came, the actual structural change did not follow at the same speed, if it followed at all. The organisations that supported Joanna's family through the Supreme Court case were vocal about what the judgment meant and what it failed to deliver. Welsh Women's Aid, which had made written submissions to the Supreme Court in support of the family, welcomed the unanimous finding that the human rights claim could go to trial, but expressed clear disappointment at the negligence decision. Their statements after the judgment pointed to a specific and uncomfortable statistic. 2 women a week are killed by current or former partners in England and Wales. They said it was vital that state agencies be held to account when they fail to take action to protect victims. They framed the Human Rights Act as the only remaining tool available to families like Joanna's, and they described it as indispensable to victims of serious crime. Liberty, the human rights organisation that also intervened in the Supreme Court case in support of the family, made a pointed statement after the judgment. They said that when a known victim of domestic violence calls 999 to ask for help, police must be under a positive obligation to respond, and to do so competently. They described the Human Rights Act as what allowed the family to make that case at trial, and they said it showed once again how indispensable the Act was. That framing, the Human Rights Act as the last line of accountability, carried a particular weight given the political climate in 2015. At the time of the Supreme Court judgment, the Conservative government had been publicly discussing the possibility of repealing the Human Rights Act and replacing it with a British Bill of Rights. That debate had been running for years and would continue afterward. The organisations supporting Joanna's family were pointing directly at a live political argument and saying, "This is what the Human Rights Act does in practice. This is a real family who would have had no legal recourse at all without it." The case also landed in the middle of a broader national conversation about how police forces in England and Wales handled domestic abuse. The summer of 2009, the same summer Joanna was murdered, had seen the IPCC launch 5 separate independent investigations into 4 murders and a missing person case, where the woman was later found dead. The IPCC noted at the time that those cases shared common issues around call handling and the management of domestic abuse situations. Joanna's case was not an isolated incident of a system failing one woman. It was one documented instance of a pattern. That pattern had a statistical backdrop. 2 women a week being killed by current or former partners is not a figure that appeared in 2009 and then improved dramatically. It is a figure that domestic violence organisations in England and Wales have cited consistently across the years before and after Joanna's death. The specific failures in her case, missed threats during 999 calls, incomplete risk assessment forms, inadequate follow-through after previous attendances, were not unique to her situation. They were recognised failure points in a system that advocates had been flagging for years. What Joanna's case added to that conversation was a Supreme Court judgment that put the legal framework in writing. It confirmed, at the highest judicial level available in the United Kingdom, that a woman could call 999, explicitly state that her ex-partner had threatened to kill her, be failed by 2 police forces through a combination of individual errors and systemic problems, be murdered while waiting for a response, and her family would have no right to sue those police forces for negligence. The law said so. 5 of 7 Supreme Court justices confirmed it. The route to financial accountability through the courts did not exist. The human rights claim remained open. But pursuing a human rights claim requires legal representation, time, money, and the emotional endurance to keep fighting through multiple court hearings across years, while simultaneously raising children and grieving. Joanna's parents and her children pursued it. They did so because they had no other option if they wanted any form of accountability beyond the IPCC report and the apologies that had already been given. The case was described by Nicholas Bowen QC, the barrister representing the family, as desperately important. Not just for the Michael family, for every woman in England and Wales in a situation like Joanna's, who calls 999 and trusts that the system on the other end will handle that call with the care that her life depends on. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. What that ongoing human rights case looked like, what became of the two children at the centre of it, and what Joanna's case ultimately left behind as its permanent mark is what Section 10 covers. Section 10. The permanent scar. What Joanna's case left behind. Cyron Williams is serving a life sentence with a minimum tariff of 20 years. That minimum was set from the date of his conviction, following his guilty plea to Joanna's murder. He admitted what he did. The courts sentenced him. He is in prison. That is the part of this case that resolved cleanly. Everything else has been slower, messier, and harder. The family that Joanna left behind, her parents, and the two children who were in that house on the night she died, did not get the clean resolution that Williams's guilty plea might suggest was possible. They got years of legal proceedings, a Supreme Court judgment that closed the door on negligence compensation, and an ongoing human rights claim that was still described as subject to legal proceedings in the joint statement both police forces issued after the 2015 Supreme Court ruling. The human rights claim, the Article 2 argument that the police had failed to protect Joanna's right to life, was allowed to proceed to trial by the Supreme Court. All 7 justices agreed on that. But allowing a claim to proceed to trial, and that trial actually happening, are two different things. Legal proceedings of this kind move slowly. They are expensive. They require the family to keep engaging with a process that forces them to revisit, in forensic detail, the night their daughter and mother was murdered. The joint statement from South Wales Police and Gwent Police after the Supreme Court judgment acknowledged that an element of the claim still remained subject to legal proceedings, and said it would be inappropriate to comment further. What that meant for Joanna's children in practical terms is something the law was blunt about. Both police forces apologised. Both accepted the IPCC findings. Both acknowledged the failures. But the Supreme Court had confirmed that those apologies carried no financial weight in negligence law. The damages that could have assisted in the financial support of Joanna's two children, that exact phrase appeared in the commentary around the case, were not available through the negligence route. A 10-month-old baby and a 7-year-old child lost their mother because of a combination of a violent man and a system that failed her. The system apologised. It did not, through the courts, pay. That outcome prompted Wayne David, the MP for Caerphilly, to raise the case in Parliament and call for a debate on changing the law. His specific argument was that police should be held to the same standard of accountability as doctors, teachers, and the armed forces, professions where negligence claims are possible when failures cause harm. The leader of the House referred the matter to the Ministry of Justice. What came out of that referral in terms of concrete legislative change is not something that produced a swift or visible result in the years immediately following. The police immunity principle, rooted in that 1989 Hill versus Chief Constable of West Yorkshire case, remained intact after the Supreme Court judgment. 5 of 7 justices voted to keep it. The majority position was that if Parliament wanted to create a compensation scheme for victims of police failures, that was Parliament's job. The courts would not do it through the development of negligence law. The 2 dissenting justices disagreed with that position in terms that were direct. Lord Kerr said that on the specific facts of Joanna's case, the relationship between the police and a known domestic abuse victim who had explicitly stated a threat to kill during a 999 call was close enough, and the failure serious enough, to justify imposing a duty of care. He called it a glaring omission. He was in the minority. What Joanna's case did change, or at least accelerate, was the conversation around how 999 calls involving domestic abuse threats are handled and graded. The IPCC's 2010 report made recommendations that both forces accepted. The mobile phone misdirection problem, The technical fault that sent her calls to the wrong force twice was identified as a systemic issue requiring structural attention. The incomplete domestic abuse risk forms were identified as a failure of process that needed addressing. Both police forces stated after the Supreme Court judgment that they took domestic violence very seriously and had worked hard to improve how they responded to domestic abuse incidents. Whether those improvements were sufficient and whether the lessons from Joanna's case were genuinely embedded in training and procedure is a question that cannot be answered with a single yes or no. What can be said is that the IPCC's summer 2009 investigations, 5 cases involving 4 murders and a missing woman later found dead, all sharing common issues around call handling and domestic abuse, pointed to a systemic problem that no single set of recommendations could fix overnight. The organisations that fought alongside the family, Welsh Women's Aid, Liberty, Refuge, continued after the judgment to argue for stronger protections for domestic abuse victims and for the preservation of the Human Rights Act as a tool of accountability. Their position, stated clearly in the aftermath of the Supreme Court ruling, was that without the Human Rights Act, Joanna's family would have had no legal recourse whatsoever after the negligence claim was dismissed. The Act was the only remaining mechanism through which the state could be called to account for what happened on August 5, 2009. Joanna Michael was 25 years old. She had a 10-month-old baby and a 7-year-old child. She called 999 and told the operator her ex-partner had threatened to kill her. The nearest police station was 5 minutes away. She was murdered approximately 16 minutes after she made that call, stabbed 72 times while her children were in the house. The man who killed her is in prison. The system that failed her was investigated, apologised, accepted recommendations, and was then confirmed by the highest court in the United Kingdom to be immune from negligence claims arising from that failure. Her children grew up without her. That is where this case ends. Not with a verdict that felt like justice, not with a law that changed quickly enough to matter, but with a permanent legal record confirming that a young mother in Wales called for help was let down by every layer of the system between her and that 5-minute response, and that the law, as it stood, had no mechanism to make that right. If you enjoyed this breakdown, make sure to subscribe. Thanks for watching, and I'll see you in the next one.